The problem with telling the truth but not the whole truth is that it foments suspicion and more snooping. Bill Morneau might believe he doesn't report to journalists and that his personal finances are none of their business. But as soon as he entered public life, and particularly when he became finance minister, his financial affairs ceased to be his own. Inquiring minds now want to know why Morneau appears to have been less than forthright about some of his dealings, specifically with regard to Bill C-27, pension legislation that he sponsored and which may have had a positive influence on the share price of Morneau Sheppel, the company in which he continues to hold 1 million shares. Last week, Morneau said he had withdrew himself on government files at least twice to avoid a conflict of interest but would not say whether the subject discussed was related to the pension bill. Ethics Commissioner Mary Dawson Sean Kilpatrick CP The Conflict of Interest Act is clear that, if a public office holder recuses him or herself to avoid a conflict, the reason for the recusal has to be declared publicly within 60 days. The finance minister did not do so, which would appear to be a clear breach of the act, were it not for the fact that the ethics commissioner, Mary Dawson, has given him cover once again. Daniel Lozon, Morneau's communications director, said Dawson advised the finance minister's chief of staff, Richard McSimmons, that Morneau did not have to publicly declare any recusals if the potential conflict of interest was caught in advance. Dawson's office explained that the establishment of a conflict of interest screen eliminates the likelihood of a situation arising that would require a recusal. The screen is an arrangement to deal in advance with files that pose a real or potential conflict of interest. The ethics commissioner recommended the screen as the best measure of compliance after Morneau was elected. The finance minister said last week that he was taken out of meetings on 2 occasions because of the conflict of interest screen and had no knowledge of what happened in those meetings because, by definition, he wasn't in them. Dawson's office suggested public office holders could be asked to leave a meeting before the last item of business is discussed, without even knowing what the item of business concerned. This would not constitute a recusal under the Conflict of Interest Act but an instance of the conflict of interest screen working, said Jocelyn Brisebois, a communications officer in Dawson's office. Except, Morneau sponsored Bill C-27, an act that would enable federally regulated businesses to create target benefit pension plans that lowered the risk for employers and raise it for employees. They are highly controversial and their introduction has been opposed vigorously by the public sector unions. They are also a business opportunity for pension providers. A spokeswoman for Morneau Sheppel last week told the National Post that the transition to target benefit plans could provide more work for her firm. In the days after the bill was introduced last fall, the company's share price edged higher, which may or may not have been coincidental. Can it really be the case that the finance minister did not discuss a bill he introduced? Is it possible that on the only 2 occasions when it was on the agenda, he was asked to leave the meeting? Lozon said there was no conflict of interest, and that if there had been, the screen would have prevented him from sponsoring the bill. Ethics crusader, Duff Conacher, co-founder of Democracy Watch, has less confidence in the infallibility of the system and the ethics commissioner. He has sent a letter of complaint to Dawson's office over what he claims is a failure to issue public declarations on recusals from meetings. He called on Dawson to recuse herself from ruling on matters involving Morneau because she advised him last year that a blind trust was not needed and that a conflict of interest screen was sufficient to protect the public interest. As soon as Bill Morneau entered public life, and particularly when he became finance minister, his financial affairs ceased to be his own, John Ivison writes. The Canadian press Adrienne Wild that makes her biased in favor of finding Minister Morneau not guilty in violating the act, said Conacher. Now she is being asked in part to judge that her past decisions were wrong, all the while serving at the pleasure of the Trudeau cabinet on a 6-month, renewable contract. It's like a layer cake of conflicts of interest, with the entire cabinet stuck together in all those layers. The perception that politicians are only in it for themselves has reached ludicrous levels. The Conservatives claimed in question period that the government only helped bail out Bombardier because the finance minister has a personal interest in the form of Morneau Sheppel, a client of the Montreal-based plane maker. Voters are so jaundiced they might even believe such distended nonsense. The use of loopholes in federal ethics laws has been recurring narrative down the years. Conacher doesn't believe blind trusts are the answer. They are a sham because the asset owner still knows which investments have been put into the trust, he said. But he has a suggested solution. All ministers and senior government officials should be required to sell their investments and buy term deposits or government bonds. It might deter some we would like to see in public life, smart, successful people who sign up to serve, not for personal enrichment. But the conflict is inherent. It's an idea whose time may finally have come. Email ivison@nationalpost.com. Twitter ivison.